Welcome to Landmark Chambers Public Law Update webinar, the winter recap. We are delighted to see so many of you. We're up to 250 participants at the moment, which is great to see. So thanks everyone for joining the session. I hope that this session will be useful and you'll find the presentations and the discussion that will follow useful and informative. My name is Alex Goodman. I'm a barrister at Landmark Chambers, and I've been asked to chair the session today, so I won't be giving one of the direct talks, but I'll be taking part in the discussion afterwards. I'm joined by my colleagues Miranda Butler and Charles Bishop. First of all, you're going to hear from Miranda Butler. Miranda has a broad public law practice with a focus on strategic litigation. In the last year, she and I have worked together on a challenge about the access to justice for women in immigration detention up in County Durham. We've worked on a case about segregating asylum seekers through accommodation at airfields, the Wethersfield airfield. In 2023, Miranda succeeded in a challenge to the cessation of support given to victims of trafficking. She's ranked by the directories for both immigration and public law and was shortlisted for Immigration Junior of the Year in last year's Legal 500 Awards. Charles Bishop practices across all areas of public law, planning, environmental law. He acts in a number of high-profile and strategic judicial review claims. In the past year, he and I have also worked together on a judicial review of the government's reliance on emergency powers to use military sites for asylum accommodation. That's already been up to the Court of Appeal and in the High Court. He's been in various cases in the courts, including cases about the Brexit withdrawal agreement, and was recently in the Court of Appeal on a judicial review about development consent for a large offshore wind farm in East Anglia. He is also ranked in the directories as one of the top planning juniors under the age of 35 by Planning Magazine. So I'm going to hand over, without further ado, to Miranda to give us the first talk, which will be about 20 minutes, and then from there on to Charles's. Miranda.
Thank you very much, Alex, for your kind introduction. So I'm today going to be talking about a little bit of a smorgasbord of issues. As you can see from my introductory slide here, we're going to cover everything from secret policies to the ever vexatious issue of how exactly to deal with urgent judicial reviews. You'll see there'll be a few common themes going through the various cases I'm going to discuss. In particular, there are recurrent issues around candor, which is useful for all of us, whoever we're representing, to be bearing in mind. So I'm going to start with a judgment that came out just last month, the case of XY. This is in the aftermath of Court of Appeal litigation in 2022 in a case called KTT and EOG, in which the Court of Appeal upheld the judgment of Mr. Justice Linden, finding that victims of trafficking who had outstanding trafficking-related asylum claims should be given leave to remain pending the resolution of those protection claims. That judgment wasn't appealed further, and so obviously represented a declaration of the state of the law, and in particular the state of the Home Office's policy with which it was required to comply. However, rather strikingly, the Secretary of State in fact decided not to implement the court's ruling and did not disclose that fact. The way in which this was done was that the Secretary of State would make decisions as to whether victims of trafficking within what I'm going to call the KTT cohort should be granted leave to remain, but then wouldn't serve them, so that individuals weren't in fact benefiting from any positive grants of leave, nor did they have an opportunity to challenge refusals of leave. The effect of that was that the entire cohort were left without leave to remain unless they happened to have it on and through another vehicle. It's well recognised in the case law, including in KTT, that the cohort of victims of trafficking within the national referral mechanism are harmed by the lack of leave to remain. And so it was particularly striking that the decision not to implement a court judgment, which would be significant in any event, related to this acknowledged vulnerable cohort of individuals. Some individuals did bring litigation challenging the failure to grant them with KTT leave in their individual cases. But even when that was done, notwithstanding the application for duty of candour, the Secretary of State didn't disclose this internal policy he had, but instead essentially circumvented the litigation by granting individuals leave on an ad hoc basis, and then arguing that the claims were academic. This pattern of conduct is something that Asylum Aid in particular investigated and brought evidence to the court explaining that it appeared that there was a secret, unpublished policy that contradicted the public policy and thereby resulted in this cohort not being granted leave to remain when they were entitled to such. And perhaps unsurprisingly, once the court had established that this unpublished policy was in operation, which was eventually conceded by the Secretary of State, the court found in quite forceful terms that it was simply unlawful for the Secretary of State to have an internal unpublished policy related to the determination of individual claimants' rights that was inconsistent with its published policy. I'm sure everybody here is familiar with the line of case law around that, going back, for instance, to the Supreme Court's judgment in Lumber. You might also be aware that just a few months ago, the Administrative Court, in a case called MXK, examined another unlawfully unpublished policy that the Secretary of State was operating. So it's quite striking that similar findings have been made within a short period of time. And Mr. Justice Lane in XY emphasised that unless and until a decision is disturbed on appeal or potentially stayed, the Secretary of State was required to comply with the finding in KTT, which should have led to him granting leave to remain to this group of victims. And the fact that he operated a public unpublished policy that contradicted that public policy was simply unlawful. And the possibility that individuals could bring ad hoc judicial reviews didn't remedy this. Of course, there is, as a matter of the rule of law, an obligation to comply with unappealed and non-stayed judgments. And the Secretary of State's response in litigation was not to disclose what he was doing, but instead to continue to preserve his unpublished policy. There are a few more interesting points in this judgment, quite apart from the core issue as to the requirement to publish policies that contradict policies that are already in the public domain, especially where they relate to individuals and fundamental rights. There was also a finding that in this individual claimant's case, in XY's case, his Article 8 rights were engaged by the failure to grant him leave to remain. As I've already indicated, like many other victims of trafficking, XY found the lack of leave to remain distressing and destabilising. Indeed, in the case of EOG that was linked with KTT in the Court of Appeal, at first instance, Mr. Justice Mostyn referred to the position of individuals such as XY without leave as being as though they were branded as criminals and dehumanised. And it was this interference with his recovery from exploitation, his psychological rehabilitation, and the distress that XY experienced as a result of his lack of leave to remain that meant that Article 8 was engaged. And there was no dispute between the parties that the result of the court's finding on the unpublished policy meant that the interference of his Article 8 rights couldn't be in accordance with the law for purposes of Article 8.2 of the European Convention on Human Rights. I thought it was worth flagging this because it's comparatively rare for courts to find that a lack of leave to remain amounts to an interference with Article 8. And this is potentially an indication of the circumstances in which such a finding might be made. there was unsurprisingly also a number of points made about the duty of candour. So there's obviously this backdrop of the policy itself being unpublished, and the fact that where litigation was brought in separate claims, the Secretary of State was not disclosing his policy. Therefore, the court found that the Secretary of State had breached his duty of candour in these proceedings as well, in XY, by failing to disclose the existence of his unpublished policy. It's only partially disclosed in amended detailed grounds of defence. And you can read the lengthy procedural background that's set out in the judgment, explaining how, after detailed grounds of defence, you have this partial disclosure of policy and amended detailed grounds, then heavily redacted disclosure responding to a partaking request made by the claimant, and finally further disclosure in re-amended detailed grounds. The court was clear that the policy, at a minimum, should have been disclosed by the first detailed grounds. And I would suggest, having not seen the pleadings, it's hard to tell, but I would suggest that generally on an issue as central to litigation as this kind of material should be coming out at pre-action stage, or at a minimum by summary grounds stage, when it's a central issue relevant to the court's determination. And Mr. Justice Lane criticised the defendant for having to laboriously drag out of the defendant material that he simply should have disclosed as a matter of duty of candour. And you'll see there's a quote at the bottom of this slide talking about the recalcitrance, unfortunately, shown by the Secretary of State in this case, which was about as far from the requirement of laying one's cards face up on the table as could be imagined. And this is a consistent theme that, as I mentioned, we're going to come back to repeatedly in my talk, because the concern here is not only that there is the significant public law error and the lack of transparency around the published policy, but that error is compounded by resistance to engage with both the spirit and the letter of the duty of candour, to engage proactively in providing full information to the court in the spirit of cooperation. Furthermore, that isn't, I'm afraid, the extent of the court's criticism when it comes to candour. Mr. Justice Lane also criticised the Secretary of State's redactions to material that were made on the grounds of irrelevance, and essentially criticised the Secretary of State for being unduly quick to redact material on the grounds of irrelevance. He emphasises that particular care needs to be taken before material can be withheld on the ground of irrelevance, and should only be done where disclosure would be positively harmful or would result in a wholly disproportionate amount of disclosure. So the presumption, the norm, is very much disclosure, transparency, even if perhaps it's not particularly relevant. And the reason for that is not only to make sure that you're not accidentally concealing something that is relevant, but also, as this quotation notes, not to lead to the impression that there might be something untoward behind the refusal of disclosure. And of course, on the facts of this case, there were serious breaches of the duty of candour combined with substantial redactions, and so one can see why the impression of something untoward, to use Mr. Justice Lane's language, might have arisen in the minds not only of the other party but also of the court. So we're going to continue with that theme of redactions by talking about the Court of Appeal's very punchy judgment in IAB. So this concerned the government's routine practice of redacting the names of what they characterised as junior civil servants. You'll see that I've put that in air quotes, and I'll come on to explain why. Essentially, what this judgment finds is that the routine redaction of such civil servants' names is wholly inappropriate and must stop. In line with the discussions we've just been having about the duty of candour, in IAB, the Court of Appeal emphasises the very high duty on public authorities as part of the duty of counter and cooperation to assist the court with full and accurate explanations of all relevant facts, and that can plainly include the identities of individuals who are making decisions that are relevant to the claim. The court also emphasised that the reference to junior civil servants in fact relates to 98% of civil service, because the way in which civil service is structured is you have a very thin top layer known as the senior civil service that has, for instance, cabinet secretaries and permanent secretaries in it. But the vast majority of the civil service, and very often the individuals who will be taking decisions and formulating policy on matters that are being litigated, would fall outside that 2% at the top of the civil service hierarchy. And so the court emphasised that the argument that was being made on behalf of the government departments was extraordinarily far-reaching, because you are essentially asking to keep the identities of 98% of the individuals who are likely to be working on cases. Something that I'm sure we've all seen in practice, which is that extensive redactions can make it very difficult to read documents. It may not be clear whether a redaction refers to a word or somebody's name. It may also mean that if you're reading an email chain, it's almost impossible to tell, is Miranda emailing Alex? Is Alex emailing Charles? Who's this responding to? The court did, however, emphasise that it's usually permissible to redact contact details, which are obviously highly unlikely to be relevant in almost all litigation. And as I've already said, this is a powerful and punchy judgment in which the court emphasised that this kind of routine redaction is not only inconsistent with duty of candour, it's inimical to open government and unsupported by authority. So whilst, of course, there is the possibility that the Secretary of State might seek to appeal this further, I would be a little surprised if permission were granted for them to do so. And if this judgment does stand unappealed, then it will put a very clear full stop on the question of whether routine redaction is permissible. I'm now going to come on to a completely different case, a case to do with unsuitable accommodation. This is TMX versus Croydon and the Home Office. And this involves a really heartbreaking case of a very severely disabled asylum seeker who has been living in a single ensuite bedroom in an asylum hotel with his two children, aged 10 and 14, and his wife. He has very substantial care needs, and in a detailed judgment, Alan Bates, sitting as a Deputy High Court judge, found that he had essentially been not just confined to his room, because the hotel is not wheelchair accessible, but confined to his bed, in which he was required to have all of his toileting needs met, because he was also unable to reach the bathroom. He was essentially dependent on very substantial amounts of personal care provided by his wife. The first question in this case was who was responsible for meeting his accommodation-related care needs. The court forcefully reached the conclusion that this obligation fell to the local authority, because asylum accommodation is accommodation of last resort, where other accommodation might be available, such as under the Care Act. It must come first. The court also went on to find that the failure by the local authority to provide adequate accommodation to meet TMX's care and support needs, in full knowledge of the terrible situation he was in, amounted not only to a breach of his rights to a private and family life under Article 8, but even met the high threshold of Article 3, given the serious and prolonged suffering that it foreseeably resulted in. This is an interesting and detailed, thoughtful judgment by Mr. Bates, who's a comparatively new Deputy High Court judge, and there's a number of rather interesting points in it that I also wanted to flag. Firstly, he emphasises that, perhaps I should say, expresses doubt as to whether at first instance administrative court judges should be applying Strasbourg judgments, which might sit in tension with domestic case law. This isn't a binding finding, as I say. It's Overturn in any event wouldn't bind other administrative court judges, but at least raises questions as to the line of travel when it comes to the duty to take into account Strasbourg case law and human rights. And finally, I thought the judgment was worth mentioning because there is a beautiful piece of judicial sassiness in it. At paragraph 91, Mr. Bates notes that the barrister for local authority said to him more than once during all submissions, "Now your lordship may say that the law's the law," whilst making a submission to the effect that I should, for various reasons, come to some other conclusion. Given that this is a court of law, it should come as no surprise to the council that I am unpersuaded by those submissions. And so I'm looking forward to more judgments from Mr. Bates, if they can have equal levels of sass in them. But I'm going to move on from TMX and touch briefly on a couple of more procedural points. Firstly, we have the case of bail, which reminds us yet again, we have been reminded before, including by Mr. Justice Gordon, who is the judge on this case, that if a case is most closely connected to an area outside London, that is the appropriate venue for it. That we should not be defaulting to London, especially where that move is done, because that is where the lawyers in the case are based. However, the judgment does also acknowledge that the parties' wishes as to venue are powerful features in deciding where a claim should be heard, and also gives some useful guidance as to the fact that where there is any issue as to venue, this should be flagged by the claimant at an early stage, which could assist a defendant in their choice of counsel to make sure that they're able to instruct counsel that will be closer to the relevant venue in which the claimant wishes the matter to be heard, rather than leading to issues down the line. This is something that's very clear in the administrative court guide, and once again really shows direction of travel, so that you have to make out a powerful case, in my view, if you're arguing for a venue other than the region with which the case is most closely connected. Finally, we're going to talk about urgent claims. At a recent administrative court user group meeting, the president of the administrative court gave what might strike some of us as slightly surprising guidance, given some of the judicial comments made in cases such as DVP and Hamid case over the past few years. He emphasised that where a claimant is seeking an abridgment of time for the acknowledgement of service, for instance, from 21 days to 14 days, that application should be made on an N463, not within the claim form, as otherwise the court is unlikely to look at the issue until the relevant deadline has already passed. And he emphasised, however, that where expedition of something later down the line is sought, such as expedition of final hearing, the use of N463 not be appropriate. Obviously, one could anticipate circumstances in which urgent directions and expedition of final hearings, in which case an N463 might be wholly appropriate. But understandably, if you're seeking a standard time frame to a commission decision and then expedition thereafter, it's simply unnecessary to use an N463, and the court would be very displeased if you do. So I thought it might be useful to give ourselves a short recap on when an N463 is appropriate. So as I've just mentioned, following on from Mr. Justice Swift's comments, it can be appropriate where you're seeking to abridge time for an acknowledgement of service. Obviously, it can be appropriate where you're seeking very urgent interim relief. Extreme cases would involve very urgent medical care, would involve removal cases, might involve things like detention or other circumstances, perhaps, for instance, such as the situation of somebody like TMX, if somebody was undergoing an ongoing Article 3 breach. However, you need to make out a strong case for urgency. I've also listed here very urgent directions. I doubt that directions not involving abridgment of time for the AOS would be likely without an application for interim relief to justify using then 463 by themselves. So extreme caution needs to be used about inviting the court to consider something within 7 days. And you need to have good evidence to show why consideration is reasonably required within 7 days. And you've got to remember that that isn't even a 7-day deadline. The N463 form only allows you to ask for consideration up to 6 days. And whilst the language of within 7 days could be read as implying a request for consideration on the 7th day, that's not how the administrative court interprets and applies it in my experience. Of course, I'm sure everyone here doesn't need to be reminded of the fact that using an N463 where a claimant is delayed is wholly inappropriate, and in particular, as the court emphasised in DVP, where an issue is no longer live for the claimant. So where, for instance, the claimant is essentially acting in a representative capacity, similarly inappropriate to ask for expedition. And of course, once again, our old friend, the duty of urgent, sometimes ex parte applications. And so one needs to be mindful of all of the points that we've repeatedly emphasised about the need for cards face upwards on the table. So what can one do in not so urgent claims? You can, of course, make an application for expedited directions or interim relief without an N463 and just use the applications box in a claim form. If you're issuing proceedings on an N244, if you've passed that stage. Mr. Justice Swift has emphasised in previous administrative court user group meetings that you should flag the urgency of the application in your covering email to the administrative court office. The phrase he used was you should write urgent all over it. He's also mentioned that if you don't get a response within your requested timeframe to these kind of applications, you can escalate to the senior legal managers at the court. And that's quite useful because in my experience, it can be hard when you're not using an N463 to get a very prompt turnaround. So those are all the points that I wanted to raise, and I'm going to hand over to Charles now for his talk.
Well, thank you, Miranda, and morning, everyone. Nice to see so many of you. I am going to be covering 3 topics today. The first one is about, sorry, I'm just trying to get my slides. Here we go. The first topic is going to be about academic cases. Second is what to do when cases settle, and in particular, the role of interested parties in that. And the third is a new procedure for permission stage replies. So turning to the first topic, academic cases, and just want to recap some of the principles on this. The principles were quite helpfully set out in the Court of Appeal case a couple of years ago called Langton. But basically, an academic claim is where there is no longer in the Latin term is a lease. I don't know if that's how you pronounce it, but that's what I think it is, lease, or a case to be decided which will directly affect the rights and obligations of the parties. So an example of this is where a public authority has agreed to reconsider the decision that was under challenge. And so it no longer is lawfully decided or not. No, it doesn't directly affect the rights and obligations of the claimant because it doesn't matter, because there's going to be a new decision. And generally reluctant to hear these cases, and they won't grant permission if in a JR or hear a substantive JR if permission's already been granted when a case has become academic, other than in exceptional circumstances where there is a good reason in the public interest in the matter being heard. That principle has been well established since at least the case of Ex parte Salem in the 1990s. So examples of where courts have proceeded to hear academic cases are where there's a short point of construction, which raises issues of general interest and where the parties were ready to argue the point where there was an ongoing relationship between the parties. So that was a fairly well-known case a few years ago called L in Devon County Council. Other examples are academic matters which raise issues, or where there are a large number of similar cases, or at least there are some other similar cases which exist or are anticipated. So generally, it's where the courts consider that although it's not directly relevant to the parties here, it's worthwhile using the court's resources to determine this issue because it might come up again, or it's going to affect other people beyond simply the claimant in that case. There have been two recent cases on academic cases which take different approaches to this question. So the first one is a case where it was AA and Sodexo, and this was a case brought by a mother who was in prison at the time, and she wanted to go out on home detention curfew. But it was argued by the government that she couldn't because she was ineligible for that, because she was liable to removal, and she was liable to removal because she'd received what was called a stage 1 deportation decision. She was granted permission to bring her case, and the court expedited that because they said it was worthy of expedition and the issue needed to be decided quickly. But after permission was granted, the Home Secretary made what was called a stage 2 deportation decision. But within a matter of days afterwards, the Home Office withdrew both of those deportation decisions. I'm using the word deportation decision. In fact, that's actually slightly controversial in the context of this judgment, but for reasons I won't get into. And in any event, the Home Secretary then made attempts to find a suitable home detention curfew address for the claimant. So the court had to determine in that situation whether the claim was academic, and if so, whether it should proceed to be heard in any event. The claimant was arguing there that actually the issue was not academic, because as the defendant didn't accept that the original decision was unlawful, but had merely just withdrawn it, the issue actually remained whether or not it was whether or not it was unlawful. But the court held that there is no decision remaining for the court to decide upon because it had actually been withdrawn. And so when the court is having in mind what remedies it might be able to grant those situations, a withdrawn decision is not one that exists for the court to quash. Although, of course, the court could nonetheless issue a declaration in that situation. But there's a reluctance there to opine on a withdrawn decision. So the court said it was an academic case. The question then, it was whether or not they should hear it anyway. And the court referred to, and was taken by the claimant, to the Zoolife case from 2007. And that suggested a slightly more rigorous approach to the determination of academic cases. That said, suggested there might need to be two conditions before the court would do it. So the first is a large number of similar cases exist or anticipated, although that then gets qualified immediately by saying, or at least some other similar cases exist or are anticipated, so maybe not a large number. And the second condition is the decision in the academic case will not be fact sensitive to that particular case. Now, in this case, the AA and Sodexo case, what was emerging from the disclosure and from other cases that were brought to the court's attention was that there did appear to be some confusion as to whether there is a two-stage process for deportation in this particular context, which was in the EU context, and the relationship between that process and eligibility for home detention curfew. The claimant produced evidence as to other cases which suggested that confusion, and the court recognized it, although didn't accept it in its entirety. But the defendant's simple position was there was no exceptional circumstances here to justify hearing the case, and there might have been other issues around detention, etc., which could be transferred to the county court. So there were, in other words, other remedies available to the claimant. But the court concluded there were exceptional circumstances here. In particular, it related to predominantly young and vulnerable people who were being detained, with the Home Secretary and individual prison governors confused and inconsistent. So the court was essentially saying there's some issue here that needs to be resolved, and so it's worthy of the court's resources being used on it. So the claim was allowed to proceed, although it wasn't expedited. However, that was only as against the Home Office and not against and the Justice Secretary, not against Sodexo, because in respect of Sodexo, it had essentially become academic. So that was that case. You then and just to say, as far as I know, I don't think the substantive hearing in that case has, but there's certainly been no substantive judgment in that case yet, despite its proceeding. A different approach was taken in the NS case, which was initially brought by an asylum seeker against the adequacy of his accommodation. And he was granted asylum during the currency of his claim, meaning he was no longer eligible for accommodation as an asylum seeker and would fall under accommodation for refugees. But his claim also included a challenge to the legality of a form of guidance issued to Home Office caseworkers called the Asylum Seekers with Care Needs Guidance. On the day of the hearing, the parties were not agreed that the claim had become academic, and so the court decided to actually hear full argument in the case. And although the court thought there was force in the claimant's argument on the merits of this case, and having heard full argument, the court said, well, the claimant is actually no longer personally affected by the guidance, and so it was academic. And the court then stressed, well, its resources should in general be used in resolving disputes of immediate and actual concern to a litigant before it, and it would not be consistent with the overriding objective for resources to be spent on litigating this issue in proceedings which, insofar as they affect the claimant, have come to an end. I do find that a slightly unusual position, given the court had actually heard full argument, but that was the conclusion that was reached. And what was interesting, though, is that the court sort of tried to give a strong indication to the Home Office that they might want to reflect on whether the guidance should be clarified or corrected, which is an interesting exercise of the court's function to make it over to comments that might assist the government in avoiding judicial review in the future. Just separately to this entirely, the court also heavily criticised the Home Office's failure to put in any evidence which explained how it had any evaluative decision-making in relation to the specific accommodation that was used in this case, and then for seeking to defend the underlying decisions. And in a passage that reflects the theme that was developing in the cases that Miranda was explaining, again in the Home Office context, court said the failure of the Home Secretary in this case to engage with the letters before claim, or often even to respond to correspondence concerning urgent accommodation needs, is sadly common in the experience of the administrative court. So I think, consistent with the theme that Miranda was developing, there's certainly a bit of a pushback from the court about having to remind central government of their duties as responsible litigants before the court. So that's academic cases. Turning then to the second topic that I wanted to speak about today, this is about settling cases. So just a recap on the procedural provisions as to what happens when the parties agree on a route to disposal of a case before a substantive hearing, before judicial determination. Where parties agree that a final order, which includes what the court in this case I'm going to talk about, called a substantive order, such as a quashing order, a declaration, where the parties agree that that should be made, the court can make that order on the papers without a hearing, but only if satisfied that the order should be made. So in other words, the parties can't merely agree it themselves. The court has itself to be satisfied that the order should be made. And the process that has to be followed is the parties must file, and generally, in my experience, it's the claimant does this, must file 3 copies of an agreed and signed terms of a draft final order, an agreed and signed statement of the matters relied on as justifying that order, and any authorities or statutory provisions relied on in that statement of the matters that justify the order. Now that's because when the court is being asked to exercise its supervisory jurisdiction to quash a decision or make a declaration, etc., the judge needs to be satisfied that there is a lawful basis for it to do so, and that needs to be set out in the statement of matters relied on. So it will say something like, the parties are agreed that the local council failed to take into account this material consideration when determining the planning application, and consequently the decision was unlawful and forced to be quashed. That kind of thing happens routinely in the administrative court and the planning court. Even if the outcome is not fully agreed, the parties can agree to a process of inviting a judge substantively to determine the issues and make the appropriate substantive order without a hearing. So where the issues might be quite narrowly confined and it might relate only to perhaps the wording of an order or something like that, then parties can set up a system for doing that without the need to expend resources on a substantive hearing. As I said, orders which grant a remedy will always require judicial adjudication. That's different from the costs position, which does not require necessarily a court order at all and doesn't require an agreed statement of justification. And that's because court orders aren't reflective of the court's supervisory jurisdiction, which is an exercise of the constitutional function of the court. So in the Kirklees case, this was actually a statutory review in the planning context. It wasn't a judicial review. And it was brought under Section 287 of the Town and Country Planning Act. For those who do planning here, that's the provision. And it was against a stopping up order, which basically prevents use of it. And essentially, the case was that order had been made without following the proper procedure, and it needed to be quashed. And all the parties were agreed on this, apart from one of the interested parties, who was an underlying applicant for planning permission. As you know, interested parties are personally affected by a claim within the civil procedure rules. There is an interesting point as to whether or not you can technically have interested parties in statutory review claims. I've certainly seen one judicial view, which is that you can only have applicants and respondents in statutory review claims, because the civil procedure rules don't specify that you can have interested parties in statutory reviews. But that didn't seem to trouble Mr. Justice Fordham in the Kirklees case. Once served with proceedings, an interested party is a party and has rights within the claim. They can, if they wish, participate in the proceedings. And although this isn't mentioned in the Kirklees Council judgment, interested parties may also be subject to the duty of candor, and that is, in my experience, a point that is often missed in these cases. And interested parties routinely don't engage when they often are required to do so under the duty of candor and cooperation by being named as a party, even if they think they don't have anything to do with it. It's always open to the interested party to apply to be removed as a party to a claim. Interested parties can also appeal a decision, even if the defendant does not wish to. And the most recent, very high-profile example of that was in the Heathrow third runway litigation, where the government did not appeal to the Supreme Court, but Heathrow Airport did and won on appeal. Interested parties can also be subject to costs orders. So if parties seek to agree a draft order which settles the case, along with the accompanying statement of reasons why, then this has to be signed by all parties, and that does also include interested parties. And the difficulty arises where you've got an interested party who isn't engaging with that process. In that case, Kirklees, 3 out of the 4 parties had agreed to everything, including even the quantum of costs. But one of the interested parties, the applicant, had not signed it, and they'd actually expressed in sort of an informal way that they disagreed with the claim and thought some of it was false, etc., which obviously troubled the judge because they didn't want to make an order that one of the parties disagreed with. But unfortunately, that interested party was not actually taking any active part in the proceedings. They hadn't provided, even as far as I could see, an acknowledgement of service or any summary grounds or anything like that. Didn't turn up to any hearing. So there was a hearing where the court, in advance of which the court ordered the interested party to file an AOS. As far as I could see, they didn't do that, didn't make any written submissions or even respond to a request as to whether they would attend the hearing. They did not attend. And as a result, the court agreed the approved order, gave a provisional view that costs of the hearing by the interested party, as they hadn't actually participated in it, and if they had participated in advance, the hearing would not need to have gone ahead, and gave a clear and open warning. And they said that the parties hadn't given a clear and open warning of the potential for costs, and that's why it was only a provisional indication that the interested party should pay costs. So the court gave the interested party time to respond on that point, and the interested party did not do so. And as a result, costs were ordered against it. So finally, turning to permission stage replies. Now, this is the process by which, after a claimant receives the defendant's and interested parties' acknowledgement of service, summary grounds of resistance, the claimant feels there is something in that they are required to respond to, and as a result want to make a reply to do so. Now, this happens very regularly. The current procedure is that you have to make an application, and really the idea is you have to do that very quickly, because there's always a risk that a decision is made on the papers before you have had a chance to have your reply go into the court and the court to take it into account. Given that this happens so routinely, but there is no formal procedure for doing so, the court has now, or the civil procedure rules will be amended from the 6th of April. So this isn't happening yet. You've got just under 2 months until this happens. There will be a formal procedure for claimants, if they wish, to file a permission stage reply, and there will be no need to make an application to do that. So the new procedure will reply that the reply must be filed not more than 7 days after service of the AOS, and there are content and length restrictions that will be set in Practice Direction 54A that will come on to. Reply has to be served within 7 days after it's filed, and notably, the parties won't be able to agree to extend any of the time limits, although of course you could always apply to ask the court to do so. So this likely means that the court won't grant permission to bring a claim for judicial review until the time has been taken for a reply to be filed, until that's passed. Because at the moment, sometimes you can actually have permission decisions in less than 7 days after the AOS has been served. But I'm assuming the court will not do that now to allow for the permission stage reply. And I would imagine if they did, there would be some procedural objections to that. So new Practice Direction 54A paragraph 7.1, a similar provision in the Planning Court Practice Direction, says that a reply should be filed only if necessary for the purpose of the court's decision to grant permission to apply for JR. So where there's, for example, a discrete issue not addressed in the claim form. I had that quite recently, where a new case came out in between filing the statement of facts and grounds and the defendant's summary grounds of resistance, which the defendant relied on in the summary grounds of resistance. And we applied to file a reply, and the court accepted that because the reply needed to address the new decision that had come out. The court says, sorry, the Practice Direction also says that a reply is not the occasion to rehearse matters already referred to in the claim form, should be concise as possible, and shall not exceed 5 pages, but the court may grant permission to exceed the 5-page limit. Although, of course, you would have to make that application as you file the reply, and there's always a risk it wouldn't be granted. So I think in practice, it's going to be very difficult to get greater than 5 pages, specifically when this is only supposed to be to allow the court to have this information to decide whether to grant permission or not. And when you, as a claimant, will have opportunities to make a reply to detailed grounds by application or sometimes by case management directions, or you can address matters in your skeleton argument for the hearing. And the court says that if a reply is filed unnecessarily, it may make an order in relation to costs, for example. So I think there's a sort of mixed message with this new permission stage reply, which is that, okay, it's going to be permitted to happen more routinely, but actually the procedural rigor that needs to be applied when a reply is made is going to be much greater. So that's permission stage replies, but only from 6th of April until then, application process. Just finally, as we're out of time, there have been a few interesting developments in relation to evidence. I wrote a blog on that as part of Landmark's new administrative and public law blog, which I encourage you all to read. Lots of really interesting posts from my colleagues on there. And I've set out on this slide just a very quick summary of some of the points in a recent blog post I wrote about witness statements, but I won't go through that now. I encourage you to read that in your own time. So that's all from me now. And I think we're handing over to questions.
Thank you very much, Charles. Yes, so first question, I think if we can get Miranda back, is from Guy Atoun, and it's in response to the IAB judgment and it's whether, as a result of the IAB judgment, we're going to now just be seeing routine use of N244 applications by the Secretary of State so as to redact. So just to go back to what Miranda was talking about, the policy of routine redactions was objected to by Court of Appeal, but they indicated you could make an application. And so the question that's been posed is, well, will the response simply be routinely to make an application? So I don't know, Miranda, if you're with us and you got any thoughts on that?
Yeah, absolutely. So my strong view would be that that would be inconsistent with the spirit and probably also the letter of the IAB judgment. The point of the IAB judgment is that routine redaction of civil servants' names isn't appropriate. The way that I like to think about it is, if I'm representing a claimant, I need to articulate a good reason if I'm trying to anonymise them. Or similarly, if I was trying to anonymise one of my witnesses, I'd need to show, for instance, they've had an outstanding protection claim, or perhaps they have a statutory entitlement to anonymity under the Sexual Offences Act. And so we have a sophisticated structure for providing for anonymity or redactions, or even a full closed material procedure under various statutes and court rules. And the point is that if a Secretary of State has a good reason to seek to anonymise somebody's identity and to seek to redact that information, they can do so, but they would have to articulate that in an evidence-backed application. And were a Secretary of State to put in an application simply saying, please give us permission, essentially for the same reasons they'd set out in the IAB, because it is our policy, because we want to protect our identities, because we're worried about a risk of backlash, that wouldn't be sufficient in my view, because those points have really been disposed of by the Court of Appeal's reasoning. Oh, Alex, I think you're on mute.
Sorry, Miranda, I'm going to ask you to take the final question in the Q&A in a moment, which is about overturning the suitability of accommodation determination. But maybe we could just fill in while you think about that with the middle question, which is to Charles, quite a hard one. It says, could the Secretary of State have appealed the interlocutory judgment in IAB to the Supreme Court, even though the main substantive claim was withdrawn? So I put that to Charles because it touches on the academic issue he was talking about, but I think it's probably mostly a pretty techie question about what the parameters of appeal to the Supreme Court might include. I don't know if you've got any thoughts on that, and if you haven't, don't worry, it seems a pretty difficult question, Charles.
Yeah, it is a tricky question, which I have no doubt that GLD and counsel for the Secretary of State in that case probably had to grapple with at some point. I would think the answer to this is that the Secretary of State wouldn't have consented to the formal discontinuance, which is actually the sort of technical term for the ending of the claim in that judgment, if they wanted to appeal. So I think what they probably would have said is would have issued some sort of halfway house position where the parties agreed that this should be the resolution to the claim, but that is sort of delayed or stayed pending an appeal on that interim point to allow it to go to the Supreme Court. And the application for permission to appeal to the Supreme Court would have been premised on the basis that this point is now academic. Because actually, in the IAB case, it was academic, because the parties had actually come up with a sort of neat solution for how to ensure that the relevant material was brought to the court and the parties' attention without it affecting the case going to the substantive hearing. So technically, I suppose it was an academic point already in the Court of Appeal. And if the Supreme Court considered it to meet their own tests for permission to appeal, so whether it's an arguable point of law of general public importance, and whether they also thought the second point, which is that it's an academic case of such sufficient exceptionality that it merits consideration by the Supreme Court at this time, then they might have done it. I mean, as far as I know, the Home Office didn't apply for permission to appeal. But I don't immediately see any sort of inherent procedural objection to it, subject to those points.
Okay, and Miranda, can we pick up the question about the suitability of accommodation?
Yes, so obviously we can't give advice on individual cases in a webinar format. Obviously there's also not a huge amount of information in there, so we can't give any sort of detailed advice. However, in principle, whether it's under housing provisions or whether it's under the Care Act, if a local authority accepts that there's a duty to accommodate and that the accommodation provided isn't suitable even for a short period, that would be prima facie unlawful, and one potentially could issue judicial review proceedings and seek interim relief. I also saw somebody in the chat asking where they could find our blogs. So obviously in the slides, you'll have the link to Charles's excellent blog. And if you go onto the Landmark website, there's a news and cases section, and there's a filter that you can go on for our blogs.
Okay, and last question, there's just another one from James Packer at Duncan Lewis about disclosing material following the IAB judgment. The point is made that in the Arup litigation, the defendants refused to provide disclosure until we, meaning the claimants, had pre-signed an undertaking not to disclose material even to our own client. He says, does IAB change that? Probably yes, because the presumption is that there will be open justice, and so it shifts the position to the defendant. That said, obviously, before you make an application, you're entitled to see if it's not necessary to make the application. So it seems to me perfectly reasonable for a defendant who says, we're going to apply to provide some redacted disclosure. Do you, A, agree to that? So we can do it by consent, or if not agree, is there some other method we can use? I find the undertaking not to disclose material to the clients very problematic, because it puts you in a compromising position where you can't actually take instructions if there's some relevance to that material. So I think I would avoid, as a matter of general principle, any arrangement along those lines. It might be more a matter of having an undertaking to have an agreement, a confidentiality undertaking by the client, for example. The other options are you can have some sort of closed hearing, like they do with special advocates and so on, but the courts are very keen to resist that, and obviously that's inimitable to open justice. Any other thoughts on those, Miranda or Charles? And we'll close after that, I think.
I was just going to note from the Arup cases I've done that Section 6 applications for closed hearings and the instruction of special advocates has been quite routine in my experience. And I mean, perhaps in those circumstances, some parties might feel it's preferable to have the kind of agreement that James refers to if the alternative is a Section 6 application. But I would absolutely agree it's an invidious position to be in. And neither of those are really consistent with the overarching principles of transparency.
Okay, thanks very much. I think we've managed to answer all the questions in the chat, and that was really super. Thank you very much, Miranda and Charles. That's a really useful little format you invented there. It certainly kept me up to date. I hope everyone else found it useful. Goodbye, everyone. Thanks for joining, and see you whenever the next season is.